Good afternoon, everyone. This has been a long yet a beautiful day for all. I'm Joanne John from third year BA LLB and I'll be moderating this session. In the previous sessions, we have come across several deliberations regarding various practical aspects of voting and the legal system. And one of these sessions have on a light on the importance of finding relevant law and the need to develop abstract thinking for a successful advocacy. We have now come to the final session of the workshop, the validatory session. May I now invite the faculty coordinator for the Moot Court Society, Professor Sankita Thomas, to welcome the gathering and to introduce the speaker, Mr. Arjun Rego.
Good afternoon to one and all. I've been entrusted with the duty of welcoming each one of you to the validatory ceremony of the one-day workshop conducted by the Moot Court Society of St. Joseph's College of Law. It is my privilege and honor to welcome among us Advocate Arjun Rego, our guest speaker for the validatory session. Sir completed his BA LLB degree from University Law College, Bangalore in 2008 and then went on to complete his LLM in International Business Laws from the University College of London in 2009. And since 2009, Sir has been working with Rego and Rego Associates. He has been a part of various prestigious cases before the Honorable High Court of Karnataka and has earned his respect and goodwill among the legal fraternity at a very young age. We are truly honored to have you amongst us, sir, and I heartily welcome you to this event on behalf of each one of us at St. Joseph's College of Law. We welcome you, sir. I would also take this opportunity to welcome our beloved Director, Father Praveen Hridayaraj, and Principal, Dr. Pradima Prabhakar, to this event. Last but not the least, I would also like to welcome all the faculty members and the students of St. Joseph's College of Law to this event. I welcome you all. Now, I kindly request Advocate Arjun Rego to render the validatory address. Over to you, sir.
Am I audible?
Yes, sir.
Yeah, okay. Thank you very much for introducing me, madam. At the very outset, very good afternoon to all of you, especially Reverend Father Praveen, the director, the principal, Dr. Pratima, the vice principal, Ms. Parikya, faculty coordinators, and students of St. Joseph's College of Law. It's indeed an honor and a privilege to be part of this workshop and to be given this opportunity to address all of you today. I congratulate the MCS for taking this initiative to organize this MOOC workshop. I'm sure it has been of great help to all of you and very greatly from what you've learned from this workshop today. I also think that you should consider yourselves very fortunate for having such opportunities in law school, because I remember back in the day when I was a law student, we hardly had any guidance or encouragement from colleges or even opportunities for moots and other sort of activities. And therefore, it is really great to see that that colleges are these days taking great initiatives and impressing upon the importance of taking up moot courts and other co-curricular activities. And these activities will help you develop your skills and surely be great use when you all enter the legal profession as advocates. Now, I mean, for law as a career, it's very heartening to note that all of you are probably are the future lawyers of our country and probably judges as well. And we must all remember that the legal fraternity is very well respected society. Everyone looks up to lawyers, and a lawyer is always called upon in times of crisis to render his advice or to come to people's aid. Therefore, as the future lawyers and as stalwarts of our society, it is very, very important that each one of us takes our time in law school very seriously, and also develops essential skills that would help us to render better service to our society and to uphold the cause of justice. Now, you must always remember that as lawyers, it is the only profession where we are called learned. That is because it comes from years of hard work and research and learning. And we are given the opportunity to develop these skills and to imbibe these qualities of a lawyer during or at our time in law school when we take on moot courts and other such activities. Now, law as an area is very vast. Right through your time in law school, you would cover various subjects and various aspects of law. The importance here is that when you do enter the legal profession, the big question mark is what kind of lawyer do you want to be, or what area of law interests you, and the best to understand or to appreciate is to what uh, we is something that will be made easy by taking on moot courts and other such activities that law school offers and helps you sort of develop your skills in. Now, now law is something that's very dynamic. Every day, law is changing, and in fact, I mean, if you now see, even this workshop is being conducted virtually. We've also made a big step by setting up e-courts and courts. I mean, there's a constant change, and what must remember here is that you can maybe replace a physical court hall or even judges for that matter. There's a talk or a move to introduce artificial intelligence judges. But so the physical courts may be replaced, judges may be replaced, but you must always remember that lawyers can't be replaced. And we are a very constant factor in the dispensation of justice. And therefore, it is very important that all of us do our best for society and help develop our skills or take on activities that develop our skills so we render better justice and are more effective and efficient lawyers. Now, in the morning session, Advocate Vikyat has also stressed upon the importance of learning. He said that 5 years is a long time where we are called upon to engage in various facets of law, various co-curricular activities, and the learning that we sort of imbibe for the time that we spend in these 5 years is of great importance because it has that added weightage. When we do enter the legal profession, we already have 5 years of experience, as he said. He said, you're already accustomed to how a court would function, how various legal procedures, all these aspects are sort of explained to you and taught to you through moot courts and other such practical activities that you will engage in your law. Now, all of you have attended this workshop and probably have a rough idea of what mooting is all about and what a moot court entails. But just to highlight, there are a few other aspects and a few other co-curricular activities that maybe one can take on to learn or to develop the practical skills that a lawyer requires. Now, in addition to moot courts, there is also another activity which is referred to as a trial. Trial advocacy is another component of law school, which I'm sure there will be another workshop or there will be other events where trial advocacy will also be taught to you all. It is basically where a criminal sort of case is presented to you, a hypothetical situation, and the entire criminal trial is conducted by the participants. So you will be arguing either for the prosecution or for the defense. You will have witnesses who will be examining them in chief, and all these very aspects which a criminal trial entails. So trial advocacy is also a very interesting co-curricular activity which probably will be introduced to you all very shortly. And maybe if some of you feel that mooting is not your thing or mooting is not your calling, then maybe you could also consider trial advocacy as another option if criminal law is what interests you. Now, in addition to trial advocacy, there is also the ADR rounds, wherein you have arbitration, conciliation, and mediation. Now, just to give you a brief idea of what these are, arbitration is a form of arbitral dispute resolution where your it's more informal. It's not as formal as a courtroom proceeding, but there a party will function as an arbitrator. You will have a client and his counsel who are also participants in the session, and the hypothetical situation is placed before them, which they arbitrate. So it's more like a negotiation where they come together and try to come to a common ground. And ultimately, after hearing both sides, the arbitrator is also a participant. He will be called upon to write an award, which is the judgment or the ultimate decision in that round. So the arbitrator is judged, the participants are judged as clients and as advocates. So that is also a very interesting aspect of law school, which is arbitration. Now there is also client counseling and mediation. Now mediation is something wherein it's also very informal, wherein the parties themselves are called upon to mediate, to discuss various issues, and they will have to arrive at a common ground where there's a give and take from both ends, and ultimately the parties come to some consensus, which is drawn up in the form of a settlement agreement. So here again, the participant is the mediator is also a participant who is participating along with the conflicting parties. There is an advocate and a counsel as well. So mediation is not as it's similar to arbitration, but I mean, let's say it's less informal when compared to arbitration. The last aspect would also be client counseling. Now, client counseling is basically where your maybe the entire round is an office setup of a lawyer's chamber, and you play the role of a counsel where a client comes to you with a problem, and so there are judges who are sitting and who are judging the round, who are watching how the lawyer, let's say, counsels his client, the advice he gives him, and whether he is able to build that rapport with the client. So these are also very interesting co-curricular activities that you can take up during a time in law school if per se moots are not your thing. And additionally, you're also maybe internships are also very important, where you internship in judicial clerkships, where you intern with an advocate or maybe a sitting judge of a court, and you understand the nitty-gritties of his practice, and you assist him in his day-to-day activities and his work in court and in his chamber. So internships are also a very important component, which help you learn the practical aspects of the life of a lawyer. Now, the last exercise would be writing research papers and publication. Now, there are a lot of people who feel that maybe arguing in court or maybe litigating is not their thing. For those people, there are also those who are interested in academics, becoming lecturers or professor or research assistants. For these people, the exercise of writing research papers and articles and these kind of things also are very useful. And they are also an added boost to your CV, because if one has written an article and maybe got it published by a reputed law journal, then these are added features that maybe add some weightage to your CV. And at the time of recruitment or at placement time, several recruiters look at these aspects in a CV to maybe to select their preferred candidate. Now, generally, just to sort of summarize, I mean, I know you'll have already had an extensive course which ran through the entire day as to what mooting is. But just to sort of summarize the entire aspect, with regard to what is mooting, now mooting is a situation where a hypothetical problem is posed to the clients, to the participants. The participants take on roles of advocates. There are a team comprising of 3 people who wherein there is a speaker and there are 2 speakers and a researcher, and the problem which is placed to them is then argued before a court, and there is also the contesting party which should counter your argument. So this is it's very important to sort of take on mooting, because this is the fun side of law school. I mean, as law students, most of us probably were inspired by watching Suits or other legal dramas and want to be the next Harvey Specter. But this mooting is that sort of opportunity wherein you have the chance to maybe live the life of a lawyer and actually understand or experience the feeling of presenting a case before a judge and arguing in a court of law. Therefore, mooting is something which is very important for law students, and something that I would urge all of you to take on very seriously and and take it on to develop your skills as lawyers. Now, the next aspect is, why should one take up mooting? Now, as I already said, and as Advocate Vikyat in the morning has said, mooting is an exercise that helps a law student develop his skills of a lawyer. Now, as a lawyer, you require good oratory skills. You need to have a good presence of mind. You need to be able to think quickly on your feet, and these are skills, and also very importantly, how to react and how to conduct yourself in a pressure situation. Now, in a mood, when you're placed in that situation, you have judges who may question that you were trying to throw you off track. I mean, you have come prepared with your entire presentation. Your arguments are all in order and systematically organized. But you have these judges who are trying to throw you off track, who are trying to disrupt your flow. And the what maybe sets apart a good mooter from a regular mooter is someone who is able to keep his composure, someone who's able to remain cool under pressure and ride the wave, so to speak, and who's able to come out of that situation with flying colors. So, mooting helps you develop those skills and helps you learn how to deal with such a situation when you are probably faced with a similar situation in a courtroom in your profession as a lawyer. In addition, you also learn researching skills, skills of drafting and writing, because drafting a memorial is something that is also in a mood. Your marks are sort of divided for maybe 50% is for your memorial marks and 50% for your oral presentation. So one would see that even your memorials are very important, and how one presents this case, how one critically analyzes and drafts the entire memorial is also something that you'll need to develop, because it would come in handy when you draft legal notices or draft claims, petitions in your career in the future. Now, in despite now, after maybe understanding what mooting is and what mooting entails, it is, I would just maybe highlight a few aspects as to why mooting is important. Now, there are essentially 5 points that I have put down, which in my humble estimation are important aspects that one would maybe gather or learn from taking on mooting. The first thing would be networking. Now, as you will know that when you take part in moot, you will be interacting with students from other colleges. You will also have judges and senior advocates from different places who are invited to judge these moots. So you have that experience and exposure and visibility where you're getting the chance to argue before maybe an actual sitting judge or a retired judge of the Supreme Court or maybe the International Court of Justice. Some moots I've also been to, like Philip C. Jessup. They have retired judges of the International Court of Justice who are invited to come and judge. So these are the kind of opportunities you're looking at, where you get the chance to actually present a case in front of these people. And the networking aspect is what I was stressing upon, wherein you build contacts. You have, as Advocate Vikyat in the morning said, that he also had mooted in a particular moot, and he got the opportunity to interact with that judge, and ultimately was given an internship at that advocate's chambers. So these are the maybe add-ons that one would probably get by taking on moots. You would build contacts with other colleges, with other students, and also understand. The way they conduct themselves. I mean, how they prepare themselves. So networking is something that is very important. The second aspect would be your research and your writing skills. Now, uh, as I already mentioned, the researching skills would help you to understand how to maybe be an asset to a lawyer. Let's say if you were interning with one during your time in law school, most of the time when you do an internship, lawyers give you research work or drafting work. And if you already got that experience, minimal experience of researching and drafting during your time in law school, whilst maybe taking on a moot or preparing for a moot, then you will definitely be an asset to that advocate, and he would definitely remember you because maybe for something that you have helped him with, or some manner in which you have reasoned or analyzed a problem, or let's say a citation that you found that maybe squarely applies to the facts of his case, and has maybe helped him argue that point and win that case. So your researching and writing skills are also very important, and these would be honed and developed by taking on moots. And like I said, it not only helps you in your internships, it will also definitely help you in your practice as a lawyer and in the future. Now, the next point that I've noted down is a building of confidence. Now, like I said, I mean, a moot court is a very high pressure situation where you're under a lot of pressure. You're being questions are being thrown at you, and you have to remain calm and composed, and be able to deal with that situation. So by mooting, you develop strong oratory skills where I mean, you are where you're able to speak effectively and confidently in court. I mean, as a lawyer, you are someone who's called upon to fight for your client. You're fighting there for the cause of justice and to uphold justice. So your client looks to you, and he's depending on you to present your case effectively before a judge. I mean, your persuasive skills are also very important because you need to, if your judge is being very difficult, or let's say refusing to see eye to eye with you or to understand your point of view, how you present your case or how you're able to persuade him is another very essential skill that a lawyer must develop. And therefore, by doing several moves and mooting again and again, every time you get better and better at it, and you develop strong oratory skills, you are able to speak boldly and confidently, and your persuasive skills also are inculcated, which help you present your case better and would be an added tool when you enter the legal profession. Now, the most important aspect of mooting is the practical knowledge that you get. Now, in a moot, you're basically, like I said, taking on the role of a lawyer or living the life of a lawyer. So you understand the courtroom procedures, you understand how an actual court works or functions, and therefore, like I said, law school is a balance of theoretical knowledge and practical knowledge. So the theoretical knowledge is what you gain from your textbooks, what is taught in class. But ultimately, for a lawyer, or what sort of makes a good lawyer stand out is how he can apply the law and how he puts the law into practice. And that is something that you would only maybe develop or get better at by doing moots, because that practical aspect, that practical training is what you develop, and you're thus able to also experience the practical aspect of law. The last aspect would be teamwork. Now, as I said, a moot generally comprises of three persons. A moot team comprises of three persons, where you have two speakers and a researcher. Now, working in a team is very important because when you're handling let's say heavy briefs as an advocate, or even for a moot as well, you essentially get maybe 1 month or 2 months to prepare for that particular moot. So in that short span of time, you have to read voluminous law journals and periodicals and citations and other commentaries to that you will have to go through to prepare for your moot. And therefore, how you work well in a team, how you delegate work, your time management, allocation of work to your teammates, and these kind of aspects are also very important because how you function as a team and how you work as a team will also help you maybe succeed as a mooter or as a good moot team, and therefore maybe help you win a moot. So time management and allocation of the workload, how you divide your work is also very important. Now, the other aspect of my speech is how to become a good mooter. Now, there are certain points that one must keep in mind. Well, to become a good mooter, the first important point is that you must know your case very well. So the facts of the case must be at your fingertips, because how you maybe twist the facts to suit your advantage, how you are able to maybe get around a tricky situation by application of the facts is what maybe the judges are looking at when they are judging you in a moot in a moot court. Therefore, knowing the facts of the case at your fingertips and knowing exactly what your moot proposition states is very important when you get into mooting. So, first aspect of becoming a good mooter is to know the facts of your case very well. You must be aware of all facts. The second aspect is that you must not when you argue. Now, what I've noticed is I've judged several moots in various law schools in Bangalore, and what I've noticed is that most mooters tend to read from their memorials. Now, the memorial is prepared in advance, and a copy is given to the judge. So the judges are obviously have the memorial before them, and they can read or look into it or look at what they want. But when the mooter tends to read the memorial, that sometimes annoys a lot of judges. Judges don't appreciate that. They prefer maintaining eye contact with the speaker, and that is what one must develop because you must have your notes or your sequence of arguments and argue from those points. Present your case. There's no, I mean, reading your case is not argument. Presenting your case and being able to maintain eye contact with the judges is a very important aspect when you're arguing in a moot court competition. Now, while preparing, it's important that you make your small points, which you can maybe quickly refer to because, like I said, when you're in a moot court, the judges are asking several questions. Sometimes questions that are not even related. They want to test your knowledge, or they also want to test and see how you remain cool under pressure, or if you're able to remain cool under pressure. So they are trying to throw you off track and deliberately asking certain questions just to disrupt your preparation. So it is always very important to maintain uh, small points which you could always fall back on in case you're lost or you're maybe thrown off track. So you're able to come back to the substance of your argument and you're able to continue from where you left off. The other important aspect is the use of citations and precedents. Now, like they say, I mean, it is your citations that you can refer to or rely upon in an argument, and those are the added aspects that go to assist you in persuading a judge. So, merely citing hundreds of cases or putting down hundreds of cases in your memorial is not going to serve the purpose because if you put down all those cases, it is very important that you know the facts and circumstances of each of those cases. Because a lot of times, mooters will just put down cases blindly, thinking that, oh, if I have many cases, maybe the judge will think that my research has been very elaborate, or I have put in hard work. But in these scenarios, the judges sometimes to test whether the mooter has actually read those judgments or actually knows the facts of the judgment will ask you, what are the facts of the judgment? Tell me what was held, what is the ratio of that particular case? And most times, mooters are not able to answer because they haven't read it. Therefore, if you at any time let's say a citation in your memorial or in the course of your arguments, make sure you know the facts of that particular argument or that citation, so you are able to present it to the judge if called upon. The last aspect would be to have a very good interactive session with the judges. Like I said, reading the memorial is not something that the judges appreciate. They appreciate a more interactive session where you maintain eye contact with them and are attentive to questions from the bench. Therefore, ensure that your moot round is an interactive session where you not only put forth your case, but you're also listening to the questions and the queries from the judges and are able to address those questions when posed to you. Now, the last aspect of my talk would be with regard to can mooting or can taking up mooting in law school help you in your career as an advocate? Now, honestly speaking, taking up moots is the most important curricular activity that you can take up as a law student in your time in college. Now, when you go for a job interview, most recruiters will look at your CV and look at the various moots that you've done. They will look at the prestigious moots that you've taken part in. And like Advocate Vikyat in the morning said, at most times no one really your marks really don't matter. I mean, I'm not suggesting that you all don't study or academics takes a backseat, but it but most recruiters and law firms while hiring their associates will look at the number of moots that a person has done, the prestigious nature of those moots, and these would only add a weightage to your CV and increase your chances or improve your chances of getting a good a placement or a job in a reputed law firm. Now, it's also important to know that when I mean when you do take up these moots, you're also dealing with various facets of law. I mean, there are moots which are on constitutional issues, on tort issues, on contracts, intellectual property rights. So most moots are maybe centered around various aspects of law and various different kinds of laws. So by taking on these moots and understanding what that particular uh, aspect of law, the field of law entails, it will also help you in making a good, wise career decision or a career choice. Because the biggest question is when I mean, I'm sure the law students in the fourth or in the third and the final years, I mean, there are no final years in law college yet, but the students who are towards the end of their career have this big question mark which is posed to them as to what kind of lawyer do I want to be? Do I enter litigation or do I take up corporate? So to know your where you stand or what appeals to you or what your calling is, moot courts help you in arriving at that decision very effectively and helps you make a more maybe a more educated and informed decision where you can take a call as to what kind of advocate you want to be. Therefore, I would conclude my talk by encouraging all of you to actively participate in several moot courts. I mean, keep in mind that the more number of moots you do or the more times you try mooting, the better you get at it. I remember judging the inter-college rounds that Joseph's College organized last year, and I was very impressed to see the quality of moots and the level of mooting. I mean, even for there were several students who were the first and second year who did a very remarkable job and excelled. I mean, for the first time mooter, they did a great job. Therefore, it's important that you do as many moots as possible and take them on when the opportunity presents itself. Also, like I said, some of you may be a little hesitant, thinking that okay, I'm still in the first year. I'm not confident. Maybe I can't present a case or maybe take on a moot right away. For these people, I would advise that maybe you team up with your seniors or others who are more confident and maybe join that team as a researcher. Because as a researcher, you're also present in that situation. You're able to watch how input is conducted firsthand, and you're also learning while being part of that entire session. Therefore, if you're not very confident in being a speaker, you can also maybe take on the role of a researcher, which will be important for you to help you gain that experience of a move. Also, maybe some of you may think, no, mooting is not my thing. I need some time to maybe assess where I stand or my abilities as a mooter. For these people, I would basically suggest that if not participating in an actual moot, maybe you join the organizing committee, the NCS, or also volunteer or maybe function as a court officer. Because when you are in that moot uh, uh, session, you're right there in front. If, as a court officer, you're sitting right under the judges, and you're able to see firsthand how a computer presents his case, how the judges pose questions. Therefore, you are getting a ringside seat of how a moot session actually unfolds, and this would be a very great learning experience and give you great exposure. And most importantly, remember that the more you try mooting, the better you get at it. And I would conclude by basically thanking you for this opportunity. I hope I've been able to shed light on facets of mooting. And what I would suggest is one very important motivator for you all to maybe excel in mooting would be the motto of your college, faith and toil, wherein it is the Josephite motto, wherein you're called to develop faith in your abilities and also toil, which is putting in hard work to become good and successful mooters. Therefore, I thank you very much for listening to me patiently, and I thank the college and the organizers for giving me this opportunity to present my thoughts and experiences on mooting. Thank you very much.
Thank you, sir, for your enlightened words. That was a highly fruitful session. Now, some of you may have questions for the speaker. You may put them across in the chat box. Now, I would like to invite the student coordinator from the Moot Court Society, Ms. Shasia, to conduct the question answer session. Over to you, Shasia.
Hello, sir. Thank you for that wonderful session. With your permission, may we begin with the question and answer round?
Yeah, please go.
Thank you, sir. So the first question that we have is, when we figure out that our written submissions have a problem, how can one cover it up during the oral arguments? This I suppose many of us encounter during our presentations.
Yeah, so I mean, probably there's no way to get around that particular flaw that you made in your memo. One thing would maybe you could be confident that probably when a moot is basically evaluated, the memorials are evaluated separately, and the judges who actually conduct the rounds are not ones who are. So maybe with confidence that the judge has not maybe noticed that flaw in your memo, but argue. So one important point that you keep in mind is confidence. Whether you're sure of the answer. Now, a lot of times the judges will ask you questions. I mean, to be honest, the judges sometimes don't even know the answer to those questions. They just ask for the sake of asking to see if the student knows it. So your ability to answer that question very confidently, and sometimes judges will say, "Oh, are you sure?" But in this case, I'm absolutely sure. Those would maybe help you overcome that little flaw in your memo, where just your confidence helps you get past that uneasy question, that tricky question where you're not sure of the answer yourself. So therefore, best way to probably overcome a mistake in your oral submissions is obviously not advert to it in your argument, but keep in mind that even if a question is posed to you and you know that it is maybe the wrong answer, so answer with confidence and hope that the judge is not aware of that there is a mistake or there is something incorrect in what you.
So maintaining our confidence throughout the presentation is throughout the oral arguments is the key to this key to this problem. All right. Sir. So the next question we have. So Arnold asks, sir, as you have been a judge for moot court competitions, what, according to you, should a good memorial have in general?
Okay. So I'm sure the workshop has maybe highlighted the various contents of a memorial and the various essential aspects that you require. So I mean, most memorials you have to start off with the statement of jurisdiction, the issues raised, your summary of arguments, your arguments advanced, and your prayer. Now, how maybe what would maybe stand or help your memorial stand out from the rest is your formatting. Now, it's very important that you maintain the rules that are set out in the competition. The competition will maybe say that it has to be in Times New Roman, it has to be a font size 12, there needs to be a gutter margin of 0.6. So these minor, and maybe also when you align your arguments, it has to be justified on either side. I've noticed a lot of times teams overlook these minor aspects. So just the presentation of a memorial, I mean, let alone the content, the presentation is what catches the eye of most judges. And if they see a very well presented memorial, maybe it's well formatted, that is one very strong aspect that will help you maybe get more marks, notwithstanding what you've said in the memorial. The other thing would be reference to several citations, to maybe commentaries, because when you study your various aspects of research, the comments of jurists and eminent jurists are also a source of law. Therefore, when you are able to maybe quote from a law journal, or maybe quote what some famous jurist has said on the point, it would also help you. It would also be given additional weightage or additional marks, because the judge will appreciate that you've taken the trouble to also read a commentary. Most students will only argue the facts and maybe rely on a citation, but looking at maybe articles and other kind of sources of law would help you get those better marks and make your memorial more effective when you're arguing or taking part in a meeting. Mr. Shazir, I'm not able to hear you. No, I can't hear you. I can see you clearly, but yeah, I can hear you now.
I apologize. It was unmuted.
Okay.
It was
Okay.
muted. I have unmuted myself.
No worries.
Okay, so there's this one question. So I suppose Anand, that has answered your question, and I'm sure many of them had the same query. This another question I've received personally. The student is asking, the first generation lawyer getting into litigation. What are the things to keep in mind when we get into litigation? As in, I suppose this is a question, though not related to moot court, but a query that fits. So your profession, as in your field as well.
Yeah. Yeah, so that's a very, very pertinent question. I mean, big question mark is do I become a corporate lawyer or do I take up litigation? Now, let me be very honest and frank with you that the life of a litigator is very, very hard. I mean, when you do take up litigation, you will be given maybe a job offer where you would be paid a stipend of maybe 5,000 rupees per month or 10,000 rupees per month. So, I mean, these are not very appealing jobs. I mean, especially when you toiled 5 years through law school, you paid very exorbitant fees and other costs that have entailed. I mean, you are obviously looking at valuable returns when you do get into the profession. That being said, I mean, it is also, I mean, maybe that bit harder for a first generation lawyer because they don't have the backing of their parents or some relative who's already in the field, who's established in the field and has an established practice. So, what I would suggest is that don't be discouraged by the fact that maybe you're not paid very elaborately or the amounts that are not very appealing. The importance that the thing you need to keep in mind is that the exposure and the experience that you gain. So when you go to a lawyer, the lawyer would obviously be teaching you various aspects of law. I mean, the profession entails several aspects. I mean, even something as basic as stitching a file to file, or how you would maybe put your papers together to file, are things that law schools don't teach you, or law students don't know. So these are very essential skills that you need to learn and keep in mind. And maybe in 5 years, when you start off practice, I would also say that you start off at the trial courts. Most people feel that okay, I'm cut out. I can go straight to the High Court. I can go to the Supreme Court. But the foundations of law are basically built at the trial court level and the district courts. And therefore, I would urge everyone who aspires to take up litigation to start at the lowest level, to come up the hard way. I mean, there's obviously, I mean, goes without saying, there's a lot of hard work that's put in, a lot of sleepless nights, burning the midnight oil, and a lot of pressure. Therefore, it is very important that you don't get dissuaded by the fact that corporate jobs are more high paying, and keep in mind that, that litigation is a very rewarding career path, and the satisfaction that you get in arguing a case or maybe winning a case for your client is unparalleled. I mean, basically, I mean, as a lawyer myself, I can speak to myself when I say this, that the feeling that I get when getting a stay order or winning a case is a feeling that you can't match anywhere else. And these are the highs and the joys of litigation, let me say. And therefore, it is important that you enter the profession keeping in mind that it is definitely a learning curve. It entails a lot of hard work, but it is very rewarding. If you take it seriously and put in hard work, you will definitely succeed and become a very reputed lawyer very shortly.
All right. Thank you for answering that. I think Sir has answered that in depth. That should have that makes it all very clear. There's another question, Sir. So they're asking, Sir, is there a sense of added difficulty when considering trial advocacy against moot court competitions? And is there any definite or minimum number that is looked at as the ideal number of competitions for seizing the best chance at big recruitment?
Okay. No, so the thing is, I mean, one should keep in mind that to answer the question on the number of moots, I mean, one should keep in mind that it is quality and not quantity. So there's no point in unnecessarily doing 10, 15 moods through your time in law school without having maybe learned or tried something different. I mean, what I would maybe suggest is look up different moods which are the more prestigious moods. I mean, there are several moods that are invitational moods. There are moods that are international law moods like the Philip C. Jessup or the Stetson moods. These moods are recognized worldwide, and therefore participating in these moods from a reputed law college would obviously give your CV that added weightage, because the recruiter would obviously be aware of that mood or would have heard of that mood, and the fact that it participates in that mood would indicate that you're a better quality mooter or you are a higher, and therefore, I mean, I wouldn't say that you do several moods, but maybe for 8 to 10 moods right through your time in law school would be an ideal number that one could keep in mind. The other aspect of the question I seem to have forgotten. I mean, what was the other aspect?
Is there a sense of added, as in, is there a sense of added difficulty when considering trial advocacy against moot court competitions? I suppose the person means. Okay.
Yeah. So the thing is, see, you can't really compare a moot court to a trial advocacy. In a moot court, it's only presentation of arguments. So there are only arguments that are advanced. But in a trial advocacy moot, you're actually conducting a trial. So if we see how a trial advocacy moot unfolds, you will have evidence being faced. You have like a murder weapon. So you have like maybe a knife put on or a gun. You will have like a bloodstained shirt. You will probably have some CCTV footage that you need to look at. So the skills of a lawyer in trial advocacy are a lot more akin to a lawyer actually conducting a trial, because he's asked to not only appreciate evidence and to apply that evidence to his argument, but he's also called upon to cross-examine a witness or examine a witness in chief. It's a very, very important skill. I mean, lawyers who are maybe even 15 years into practice still find it very difficult to examine. So that is only because they haven't really done it. And to be very honest, trial advocacy is very new. In fact, I was in person. We didn't even have a trial advocacy group. So the fact that I have that opportunity, have that chance to actually cross-examine and to also maybe experience that aspect of the trial is very important. So therefore, I would urge you all not maybe to just focus only on me, but have a good balance of support, of ADR rounds, and of trial advocacy. So it has a balanced flow, and Europe is also, I mean, more sort of rational and balanced. That,
All right. So the rule is quality over quantity, and having a variety of mood always, as in variety of mood codes and trial advocacy. All these also helps in your CV. I
Yeah.
hope Aditya, that has answered your question. We have one more question, which how can we improve our oratory and presentation skills, especially when you aren't entirely confident? This,
okay.
sir, I suppose, is a question of not just the first years, but I'm sure for the seniors as well. Many of us are still struggling, so this is an important question.
Okay, no, that's a very pertinent question. I mean, that's the question that I asked most, seniors and peers when I was also a law student. So, one very important thing to keep in mind is your preparation. So, like I said, I mean, if you know your arguments very well and they're at your fingertips, that takes away half the, that's half the problem solved, because you know your substance, your content is there. The other thing is how you present. Now, what our seniors told us and what we were taught in law school was to practice before a mirror. So, actually, arguing before a mirror will help you. Not only will you be looking at your mannerisms and your mode of presentation, but you'll also gain that confidence of being able to stand up and address maybe a gathering or like it gives you that practice of addressing a court where you speak freely and boldly. So, I mean, so preparation, knowing your content very well, also your practice obviously practice is perfect. So the more times you do it, the better. So in addition to maybe practicing before a mirror, you can also maybe practice before your classmates, maybe your seniors. You can have several rounds of mooting before them, where you gain that confidence the more times you do. So those would obviously help you. And yeah, that would be the answer.
So knowing your content is very important. So when you know your content, you are confident. The confidence comes automatically, and then practice makes a man perfect. I think that befits the answer here. So I hope that has we have sir has answered your question. So we have one last question, if you don't mind taking this.
Go ahead.
Okay. So they have asked, what are the differences between the written submissions in a moot court and in an actual case?
Okay.
I suppose they're asking how does it differ?
All right, I got that. So now, I think you need to also keep in mind that what you see or how a court code actually functions is not practically what actually happens in an actual court of law. I think in the morning, Advocate Vikas said that there are adjournments in court, and you don't have adjournments in a moot court. So yeah, it can be very frustrating when you go into a court well prepared and ready to present, and the other side maybe comes and takes an adjournment, or the judge is not prepared, or because of the volume of work or the case load on the judge, he is not inclined to take up your matter on that day. So it can be very frustrating when you go well prepared to court and you don't get the opportunity to present yourself. But to answer your question as to the difference between how a moot memorial is prepared and how an actual a court case is filed, that probably you will come across the subject in your years in law school, which is DPC, that is drafting, pleading, and conveyancing. So in that particular subject, they teach you the nuances of drafting. So you need to keep in mind. So there are certain rules of drafting. One very important rule being you plead. This is for court specifically. You plead fact and you don't plead law, and you plead only material facts. So when that is the basic rule of drafting, it is different in a memorial. Because in a memorial, you plead the fact, you plead the law, you plead the citations. You also mention your analysis of that particular problem and the conclusion. That's basically how a argument is structured. But in a court of law, you are only pleading the facts of the case. Your arguments and evidence come in at a different stage in the trial. So in a court, you are only giving the facts. You're presenting the facts to the court for the judge's knowledge. The arguments and the evidence will come in later. But in a moot memorial, it is all in one. It is the facts, the arguments, your citation, evidence relied upon. All that is packed into one document, which is your memo. So that is the essential and fundamental difference between a memorial and a pleading or a petition or a plaint that you file in court.
All right. I'm sure that has answered the question. The difference between a written submission in an actual case and a moot court. Moot court has everything involved in it, whereas obviously the cases that we see at courts, they are at different stages.
Yes.
So Rishika, I hope that has answered your question. With this we conclude the question and answer round. Thank you so much, sir, and over to the moderator, Joanne.
Thank you very much.
Thank you, sir, and thank you, Shazia. May I now invite our Vice Principal, Ms. Pauline Priya, for the formal vote of thanks.
Good evening to all of you. On behalf of the Moot Court Society of St. Joseph's College of Law, I thank Mr. Arjun Rigo for delivering the valedictory address. Sir, you have brought to the table your rich experiences from the field of mooting and how you can put them to the best advantage in your courtroom practice. I am sure our students have much to gain from this session. I thank my colleagues, Mr. Sudeep and Ms. Sangeeta, for meticulously planning and executing today's program. I'd like to thank Mr. Parikshit for helping the MCS live stream the program on YouTube. Today, I am also a proud teacher. I exude with pride over the dedication and commitment of the MCS committee. I'm sure that there are many of us here who haven't mooted as yet. We're still jittery about the idea of mooting. I'd like you to look up to your seniors, Shazia, Diksha, Himali, Joanne, and Miss Simi, who have put long hours of work. Students, can you please switch on your videos? Himali, Shazia, Diksha, Joanne, and Simi, can you please come on video? Students, take a look at your friends. They were also a bunch of nerves when they started off. Today, they've progressed enough to train others on how to moot. We learn best from our own. Look up to your seniors. The MCS has also constituted a help desk, which we will shortly disclose about. The help desk aims at helping you not just calm your nerves, but learning fascinating details about mooting. Kudos to you girls. You've done a great job. Students, you can never learn to moot unless you begin mooting. Get over your fears. Get started and begin mooting. We have the interclass moot court competition coming up very shortly. We hope to see you all there. I would like to extend my wholehearted gratitude to the Director, Father Praveen Hridayaraj SJ, the Principal, Dr. Pratima Prabhakar, and all my colleagues for their constant support and encouragement. Finally, I thank you all for your encouraging participation. Feedback forms will be keyed in the chat box. Please do remember to submit them on time. Thank you all. Good evening.
Thank you, ma'am. I thank all of you for enthusiastically joining us for all these sessions. I hope this was a fruitful learning experience for you all. Again, reminding you all of you to kindly fill in the feedback forms that we have sent across to you in the chat box. Bye and have a nice day.
you.